Hey y'all, I'm Ada K, and I must confess, I'm a trial junkie. I enjoy viewing trials as if I was the seated juror. So grab a cup of java, get comfy, and join me as we hop into court. And don't forget to comment, like, and most importantly, subscribe. And if you're really enjoying the channel, please join our membership. Well, good morning. Boy, we've got a busy day. Yay. I'm saying good morning to a few friends. How are y'all doing? I am awake. No coffee yet, but I am here. I'm going to be doing 2 lives today. They're 5 minutes apart. This live is going to be the Sarah Boone motion hearing. Let's see if she got some snacks for court today. Yeah. The other live, we will be continuing the Melody Walker Ferris fire pit murder trial. So, and I may be doing a third one if this live here is still going when we do the Tellus sentencing. So, thank y'all for joining. I welcome you here this morning. And do you know what? Grab your favorite cup of coffee. Sorry, my hearing aids are hot. There we go. Now I can speak. Get your favorite cup of coffee. I am while we watch our fabulous sponsored video. Hey, y'all, please help me welcome the Hitchman Homestead Coffee. They are fabulous. They have many different blends of freshly roasted, freshly ground coffee. They have a monthly club where you get 4 bags for $40 or a Keurig option. Also, they just came out with a half and half. Oh my gosh, I absolutely love it. So do me a favor. Go down to the link below at hitchmanhomestead.com. Order you some coffee and show them some love. Well, I'm back, y'all, getting everything all set up. I am so excited. I have been waiting for this too long. But we've got Sarah Boone up and waiting. So as soon as that hops on, we'll be there. I am going to, in about 2 minutes. Oh, I'm frozen. What's going on? Hey, am I frozen? Am I frozen? Oh, there I am. Yay. Okay. I am going to be hopping over and starting that live, and then we'll be live on both of them at the same time. So, yay. If you're here for the first time, please say hello. I'm Ada K. I will not be interpreting today, but tomorrow I'm going to be interpreting. So it's going to be awesome. Awesome. I cannot wait to get all that together for you guys. We'll see if my computer can handle all these lives at the same time. This is going to be awesome. So, for those of you who don't know, and I can't believe you wouldn't know, Miss Boone is charged with unaliving her boyfriend, longtime boyfriend, fiance, in a suitcase. She says that they were playing cards and games and doing arts and puzzles. God only knows what all. And they had been drinking and they decided to play hide and seek. And she went up into the bathroom or the shower and he didn't come find her. So she went down and saw him curling up in a suitcase. And she decided to zip it, leaving only 2 finger width holes for him to put his fingers through. And then she started abusing him through it as a payback for what he supposedly did to her by battering her and choking her and being belittling. In other words, she's going to claim battered spouse syndrome. That's where we are. So we're going to pause right here. I'm going to pop up this on stage and I'm going to go open the other trial, the other feed. I'll be right back. Okay, now I am live on both feeds. Yay, y'all. This is fun. Good morning, Ronnie. Thank you for being on both my feeds this morning. I'm loving the dual lives here. It's going to be a little bit of this, but I can do it. I know I can do it. Let's see. That's the one I want there. And I may have to go to the third one with the Richard Tellis sentencing. It's going to be at 10 o'clock. So, or is it noon? Anyway, we'll see how long these both go. We'll figure it out. Don't want to miss a moment of it. So, did y'all grab your favorite cup of coffee? I haven't yet. I'm busy this morning. How are you this morning, love? How is my favorite mod? All my mods are my favorite, but Ronnie, I sure do love and appreciate you for hopping on this morning. So, the docket today is going to be a little crazy, so I hope you guys can bear with me, but I'm excited to have the technology to be able to do this. It's awesome. Awesome, awesome, awesome. So yesterday, oh, by the way, I did look up in the Boone trial, in the Boone court documents, and there was nothing filed as of 30 minutes ago. And I am so excited. There was nothing else because I was waiting for there to have an official motion hearing on whether or not Miss Boone can have food in court. She wants her snacks and she's demanding her commissary be waiting for her when she returns to her cell every night. So I guess And the commissary was, let's see if I can find that again. Was it you, Miss Ronnie, who posted the commissary request? Nope. Who posted the commissary request? There was a commissary request posted, but it was chips and mint, I believe, and oh my gosh. I know, right, Ronnie? You've been checking for the Boone documents as if it's a winning lottery ticket. Hey, Ronnie, you're answering on the wrong live, but it's okay. I'm going to our mod section right now. I'm going. I got to run multiple things. In our mod corner, here it is, you guys. Okay. Ronnie, we're going to have fun. You're answering me in the Walker Ferris case about the, oh, there it is. I was just getting ready to read it, but thanks for putting it up in front of me. 5 peppermints, 2 juice boxes, 1 bag of candy, 2 bags of chips, Pop-Tart, or a bag of cookies. Isn't she so special? Oh my gosh, it's too early in the morning for this, y'all. It really is. Oh, Lord have mercy, this child. I just I just can't. I just can't. Just can't do it. 1,000 points a lot. If y'all know where that came from, I'm impressed. Who knows where the 1,000 points of light came from? Who's gonna be my winner? Okay. Boone trial, now they're saying it was supposed to be 8, now it's 8:15 AM. So over here on the Melody Walker Ferris trial, the court is getting ready to start for the day. Yay! I know, I think she's forgotten about what she did to George. No food, no water, no nothing. Yeah, go figure. Yeah, the sense of entitlement runs deep, very deep. Okay, guys. So in the Melody Walker Ferris trial that I'm covering over here, the court is coming in. We can see some camera wiggles and some sound is starting to come through. I'm going to get my cup of coffee. Yes, coffee going. Oh, I found that it was very interesting that her clothing yesterday matched the the wood in the walls and the material on the chairs. I mean that the colors of that sea green just did not make her look sick. I want to know where she got that custom fitted suit. That suit was a tailored suit. My humble opinion, that was a nice suit. She can thank the county for that. Yes, she can. So in the Melody Walker Ferris trial, for those of you who don't know, who've been on the Boone boat, if you want to hop over to the little canoe next to you into the Melody Walker Ferris, it's one of those sleeper ones. It's a good case. Interesting things that are happening. I've never seen a trial where the attorneys are not objecting and the attorneys are allowing the witnesses to testify in a narrative form. I mean, they're just letting them roll. I'm like, objection, question asked and answered, objection, relative objection, not answering. I mean, I would be objecting all over the place. And the judge even commented and made the comment, you groomed your witnesses to do that. Nobody's objecting when they should be objecting. He kind of smacked the lawyer's hands. We've had a couple objections since then. She is accused of unaliving her husband, who was a an attorney who made really good money. They had the finest of everything, but to the point that he was in a position that if he didn't work, they'd lose it all. They had all the ATVs, they had the house, they had the silk um, cushions on their dining room tables and their plush leather couches. I mean, they had it all. And he had a little fling with his um, secretary assistant years ago, and then his wife started cheating on him, and she was spending money as if it was water. She was just going through it. There was marital strife there, and he ended up with a gunshot wound to the that had a bullet that landed in the inside of a rib cage. So that would imply that it went through the abdomen, and they've been arguing in court on the defense's side. How do you know it went through the abdomen? And I'm like, dude, a rib is curved, and the inside of the curved is inside the abdomen. On the outside is the outside. So anyway, it's been a little bit of a fun one. You just want to yell at the screen at them. Some of the craziness that's going on over here. And then he was, uh, I'd say 90% burned in a burn pit. Not much left of him. And so we are in the middle of the prosecution. They have the granddaughter. Now, both sons and one daughter has testified against her. And now a granddaughter who I think is about 17 ish. She's not an adult, but not 18, but I think she's like 16, 17. They were trying to get her up on Zoom yesterday and had a little complications. So that did not happen. I really hate putting young people up on the stand like this. I will say that Melody Walker did get emotional when the sons were on and the daughter was on the stand. But I noticed that when they were showing the remains of the husband, no emotion whatsoever. So over on the Boone side, in the big Boone boat, um, I wonder. Every time I say that with Sarah Boone, I want to start singing the song "I Wonder as I Wonder." Excuse me, I dropped my creamer cup empty. Um, how far the judge is going to let her go with some of these requests? Um, I don't see anybody else snacking during court. I don't see that why she should be permitted to snack in between breakfast and lunch and dinner. Now, if she wants her snacks after court, because apparently she's being awakened at 2 a.m. and to get ready for court, and she doesn't get back until 9. So maybe she doesn't shower and everything when she gets back. So maybe 10 is before she 11, 12, 1, 2. That's 4 hours sleep. That's tough. That's not an easy schedule to maintain. However, um, I can understand after the dinner that she may be given, she's wanting something to hold her up through the night. But I'm going to be shocked if they sit there and allow her to snack during trial. I mean, what are your opinions? Do you think she should be permitted to chow down during the middle of trial? And I don't think she needed a hairstylist and a makeup artist. She don't look too bad. And by the way, all the videos we've ever seen of her, she's never had makeup on. And if you notice, her hair is in far better condition now than it was when she was drinking and doing all that. Okay, guys, I'm going to mute the Boone, and I'm going to be over here for a moment. Hello, Seeking North Nude. How are you? The snacks are for breaks. Okay. She's gotten very comfortable in court. Yeah, she looks just we're back over to Boone. She looks just like one of the other attorneys, which is, I think, the goal. She wants them to see her as, professional and cleaned up as possible. And that's understandable. I mean, you wanna put your best foot forward, but it just the way she does things is just absolutely kinda rubbing me raw. Seeking North Nude, this is your first time joining us. Thank you so much. We appreciate you. For those of you who are just hopping on, I have a dual live going right now and may end up with a triple. So on this side of the boat, I have Sarah Boone, motion hearing. On this side of the boat, I have the state of Georgia against Melody Walker Ferris, the fire pit murderer. Oh, well, you're welcome. We love Sarah Boone. We can't get enough of Boone. But I have to tell you guys, the Melody Walker Ferris trial is a what I call a sleeper, meaning it's interesting. It's more than I thought it was gonna be. I thought this was gonna be a simple open and shut case. Far from it. So when we're done with Boone, if y'all wanna hop over to that one, please do so. It is interesting. Well, commissary is closed by the time she gets back from court, yeah. But I don't understand why the attorneys aren't getting her snacks. Usually when you're in a court situation like this, from personal experience, no, I was not the defendant. I was married to a defendant. Any and all food and everything is provided by the law firm, and of course, it comes out of the bill. I mean, you gotta pay them for it, but they actually have somebody, one of their lower level lawyers or, one of their interns, if they have one, is responsible for making sure that you get your food and making sure that you have hydration and all of that. So I'm kind of surprised that they are not doing that with her. Now, I find it interesting if you wanna look in comparison with the Melody Walker Ferris trial, she's sitting separate from her attorneys. She is very quiet over there. She's not talking to anybody. She's just a figure sitting in a chair. I kid you not. Every once in a while sorry, I got an itch. Every once in a while, she will, sit there and, kinda throw a little comment here and there. But in general, she is a mouse. She is a wallpaper, and you almost forget she's there. Very big contrast compared to the Boone trial. So, the judge over at the Ferris trial is country and just as technically savvy guy who's very relaxed, very comfortable. Um, it's a very vastly different environment over there. And then there's Boone. Hello, ADHD Jelly Bean. Thank you for joining. I love my law nerd. Thank you so much for hopping in. So we've got two ends of the spectrum going right now. So it's pretty interesting. So please join us over at the other trial if you wish after the Boone is done. Who is blowing up my phone this morning? Someone is just literally blowing up my phone. There we go. I turned that off. We are going to, once the Boone trial starts, we're gonna start having some fun recap nights. We're gonna be, part of it will be just watching and supporting Trial TV Live. They are there with Jules, and they will be at the courtroom. Jules will be inside the courtroom paying attention to jury reactions and all that, and Trial TV Live will be streaming live from the courtroom. We will want to support them, so we will be hopping on with them for their, breakdown of what happened in trial, and that will be exciting, and I hope to get Jules on every once in a while on this side. That would be fabulous. Hey, y'all. Yes, I'm sounding Texas today. Um, so we have Squeegee of Justice and Jules representing in the Boone trial at the courthouse. So, yay, they are there. Hallelujah, hallelujah. Someone shouted at me, "Good morning, therapist, you know." Good morning, Julie. Good morning, everybody at TV Trial Live. Trial TV Live, that's my dyslexia kicking in. I appreciate all of you guys. You're fabulous. We love them. And of course, yes, this is the chat popping up on that end. We are still waiting for the Melody Walker Ferris trial to start. It should have started 20 minutes ago. Oh my gosh. Okay. All right. For those of you who don't know, we do have a members only live coming up. But every Saturday we go and we have Saturday, I changed it. Every Sunday we have Sunday Night Live. Please come and join us. That's open to everybody. And then once a month we will have our members only live. Our next members only live will be happening November the 2nd. 2 days after the Halloween live, we're gonna have a Halloween, um what day of the week? Is that Friday? That's on a Thursday. We're gonna have a Halloween night. We're gonna have fun. We're gonna be able to poke at all these court cases and just cut up and let loose. So come join us for that. I'm looking. Supposedly, we have less than 5 minutes before the Boone trial goes live. Okay, now we have okay, why am I not hearing sound in this case? I should be hearing sound. Oh, I guess they don't have sound up. How interesting. Let me refresh, guys. We do not have sound. Okay, we'll see what happens. Worst case scenario, I will pause. There we go. Okay, guys, Melody Walker has started. Uh-oh, the judge is going off on a rant. Oh, guys, y'all need to hop on over while you're waiting. The judge is talking about rants. Oh, he's going off on a rant, y'all. He's a techie. I knew it. Oh, y'all hop over. He's raging. Ooh, $35. Oh, that judge ain't happy. 6 months he's been having problems? Oh, no, he didn't. Y'all just missed it if y'all weren't over there. Okay, let me tell y'all both what's happening at the same time. This poor judge has been struggling with the sound and with technology in the courtroom. He is a major techie, and he has come off the bench a couple of times to assist the lawyers on both sides with tech issues. Well, last night he stayed after hours for a couple of hours with several other people that work for him, and they finally tracked down the audio issue to a audio cable that is under his desk, which has been zip tied and been giving them hell for 6 months. And said, that unfortunately, there is not a tech person in his county to call for assistance like other places have. And they should have a tech person for the courthouse because there are 10 courtrooms in this courthouse. And it shouldn't be his responsibility to ensure the sound for all of us in TV land. He's such a cool dude. And that was such a polite rant. I love it. It was so awesome. Okay, we're still waiting for Miss Boone to start. Until then, we're over here. Y'all roll that beautiful footage. Yeah, she's a high school kid. She's a high school kid. So they're gonna skip her until later. Mm, the judge needs a Braxton. I miss our Braxton. Y'all reach out to Braxton. Okay, first witness of the day in the Melody Walker Ferris trial. Bring the microphone down, dude. Thank you. Okay, I'm going to mute the Boone people. I'm gonna put up some music, and I'll be back when the Boone starts. I'm making fun of the investigator's name. It sounds like she's saying butt bong. Don't know his name, but that's what it sounds like to me. Okay, guys, we are waiting for Sarah Boone to come on right now. I have on my other feed, we have the Melody Walker Ferris fire pit trial that has started, but we are anxiously awaiting for Sarah Boone. Butson. What a name. Butson. But he was a butt of everybody's joke. That's bad. Oh, I am in a mood today, y'all. Sarah, better behave because I'm going to be coming after you if you don't. As soon as Sarah Boone begins, we will be back. Actually, I think Sarah Boone is behaving ADHD Jelly Bean Leonard. I really think she is. I'm really surprised she's behaved as much as she is. What's going to be interesting is seeing her in trial and see how much she controls her talking to her attorneys. If the lead attorney is smart, he has assigned one attorney to speak to her and nobody else. If that attorney is smart, he has told her, do not interrupt anybody, do not say anything to any of us except for this one. He is your point of contact. Talk to this one attorney. That way she'll leave him alone. But she's already passed him notes in the jury selection, and he looked at the note and just kind of crushed it up in his hand. So we'll see how she behaves, but I don't hold up much hope. We've gone techie over at this trial over here, so I'm going to let them run. Oh, come on, Miss Boone, y'all late. Oh, yesterday, the deputy sheriff, she came into court with his the suit itself was fine. The sea green top just didn't work for me. But she came in a knee length dress suit, and in her little slip-on shoes from the jail. And the lady from JAC brought her shoes, and the deputy sheriff, of course, had to check them. And then he politely put them on the ground and pulled her chair out, and she put them on, and then he pushed her chair in. I thought, man, he's being a gentleman. I'm impressed. Most people aren't. So, yeah, we'll see how she's going to do today. I'll be right back, y'all. Got to go over here. I sure would have my moments, my dear one. Sure would have my moments. I'd set her down in a chair and say, zip it. Fire me and go to jail for life. Otherwise, zip it. Yeah. I think she tolerates a lot more for this law team because she knows it's her last hope. period. Judge ain't putting up with no more. Really? You think? You think? I'm not too sure. There's still reports of her and her attorneys yelling at each other sometimes in the jail. I think this is a good lawyer for her because I don't think, he's not gonna let her run him all over. Now, he may do some things to appease her, but he's a no nonsense kinda guy, and he's getting in there, and it's like, "We gotta get this done. Let's go." Ugh, I'll tell you what, he's gonna earn a lot of respect from all of his colleagues and everybody else if he can pull this off. No matter whether she's found innocent or guilty, if he can put on a good defense and not kill her, well, I shouldn't have said that, unalive her. Yeah, I agree. Um, yeah, it'll be interesting. This is gonna be interesting. I wanna see how he is going to control her and who's the dog with the leash, so to speak, in his team, who has that responsibility. I don't know why the delay, you guys, but we apparently have a delay this morning in the Sarah Boone motion hearing. Um, yep, they may have a problem with her getting transported. I don't know. Maybe it's a problem with getting into the courthouse. I hear the lines are insanely long over there. Aw. So we're just gonna hang. We're just gonna hang until we know better, y'all. I apologize. Nothing I can do. I'm with you. If y'all aboard, hop on over to the Melody Walker Ferris trial. I'll let you know when Boone's live. I wonder if Sarah Boone did not get her shoes today and she's refusing to enter the courtroom. I know we're so mean to her. We really are. In a way, it sucks to be her. She's the butt of everybody's jokes right now. She's not need to be actually. Sometimes lawyers have an act that they put on. They can fool you into thinking they're less than what they are. Their capability is more, and then they hammer you in court. So we'll see. I have some hope. Not much, but I got some. So day before yesterday, the 14th, there was a motion filed. Um, See if my brain will function that far back. To omit some evidence or not allow some evidence in. There was some last minute disclosure of evidence from the defenses to the prosecution side. They were not happy about that. I can understand not being happy about that. Let's see if I can pull that motion. I should be able to pull it. So, as of yesterday, they had 54 qualified jurors. Let me move this over here so I can read it. So they had the 54 qualified jurors as of yesterday. Yay! That's awesome. What notification was that? Oh. So that's a good thing. So the state's response to the motion is this, and we'll go ahead, I'll just try and read it quickly while we're waiting. Sorry, I'm trying to get it up to where I can see it. Okay, the motion is state's objection and motion eliminate to exclude defendant's medical records. As of tonight, the state received 550 pages of medical records regarding medical treatment the decedent received in 2017 and 2018. The defendant acquired these records in January of 22. So this is an issue. So Boone and her 8 other attorneys have had, including the ninth one, this information since January of 22, and they did not turn that over until the evening of the 13th or the 14th. Let me see what time this was written and submitted. So the evening of the 14th, this was submitted at 9:14 p.m. So they're objecting to allowing this information in. The state adopts all the state adopts, let me get this where I can read it better. All the arguments and authority cited in the state motion in limine to exclude the battered spouse syndrome evidence or exclude mention of the battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force. So the prosecution in the Boone trial is trying to get, the defense is trying to get into this trial the battered spouse syndrome admitted as evidence prior to her taking the stand, and that's not the way this works. The evidence must come from her testimony and from her justifying the use of deadly force. They're trying to use the battered spouse syndrome as an actual defense when it's not. She unalived him, but this is what the battered spouse syndrome is, more of an extenuating circumstance that can be applied for justification for the behavior, not an excuse of the behavior. The defendant, even in her most recent interrogation of what happened on February 23rd of 2020, had not set forth legal grounds to claim self-defense. Why? Because she kept saying it was an accident and said it over and over and over again. So at this point, there is no just cause for the battered spouse without her testifying. Assuming that she does so in trial with a different version of events, then the prior incident of violence committed by the defendant that she was aware of would be admissible to show reasonableness of her fear of immediate great bodily harm or death. Well, that means that she's going to have to backtrack on some of her evidence and come back in and add more evidence and more testimony and really explain more as to the behavior and really dive into the actual battered spouse syndrome if it really was there. Her story has changed a lot. It is evolving with every telling, so we'll be interested. Hello, Miss Karen. Hello, how are you? We are still waiting for the Boone trial to start. It should have started almost an hour ago, 43 minutes ago. Something's going on. And I'm getting ready to get my yawnies. I do have 2 trials going on at one time, so if you see me muting and bouncing back and forth, that is why. In the record, these records are irrelevant. 487 pages regarding an incident that happened on December 24th of 17, where the decedent was beaten so badly he needed facial surgery, reconstructive facial surgery. This is not relevant to whether the decedent committed a prior act of violence that the defendant was aware of occurring. If the incident that resulted in these injuries is somehow made relevant, so something happened to him with another person, not her. If it is made relevant, the severity of the decedent injuries is not relevant. If the incident that resulted in these injuries is somehow made relevant, comma, the severity of the injuries is not relevant, period. Interesting way of phrasing that. Good morning. If the severity of these injuries are somehow relevant, then the defendant should narrow it down to the pertinent narrative history of what the decedent had said happened and the treatment provided. This can be done in a handful of pages. So basically, they're trying to hide stuff. They gave them a ton of papers, and only a few of them could potentially be used in the case. That's called keeping them busy. That's a diversion. Oh, excuse me. The 2018 incident is also not relevant. The history provided by the decedent was that he put his hand through a glass window before, the day before, and the wife made him go to the doctor the next day. He received 2 sutures to close a 4.5 centimeter laceration. Oh, come on. 2 stitches? Please. Assuming the defendant testifies in the manner to make the incident relevant, a couple of pages of these records with a narrative of what allegedly happened and the treatment provided is sufficient to corroborate her testimony. Burying the jury, and this is the other thing, the jury's going to get all this evidence. And one of the techniques people do is bury the jury in evidence. Burying the jury with 550 pages of records when nearly all of them are irrelevant, when given the defendants every benefit of doubt on relevancy, is unnecessary, and prohibitive value is substantially outweighed by the danger of unfair prejudice, confusion of issue, misleading the jury, and needless presentation of cumulative evidence in the Florida State Statute of 90.403. Therefore, the state objects. Go figure. I'll be back. I'm sorry, y'all. Had to get a little bite of my breakfast. I'm glad you got some help, Miss Toxic. That's awesome. That's awesome. For those of you who are just hopping on, thank you so much for joining. We really appreciate you guys. You are simply amazing. We cannot do this without you. I am looking, excuse me. Oh, the potential witness list for Boone. I was kind of go over that. I had somebody ask me if we had a potential witness list for Miss Boone. And since we're almost an hour late in starting today, let's kind of go over that. It's not a huge list that I do have, but I do have a list. And thank you for those who have helped with this list. I greatly appreciate it. Toxic, that is so awesome. I am so happy for you. And yes, ASL is definitely a bonus. Didn't mean to do that. I'm sorry. Oh, my bad. Hit the wrong thing. Sorry. So back over to the moon side. Sorry, we've got multiple trials going today. So on the Boone's list, we have kind of sort of an alphabetical first name order. Diane Johnson Carwise, she is the community corrections officer. CSI Melissa Rothengarden, evidence collection. Brian Boone, ex-husband, is actually on the state side. I do not see him on the defense's side. Dr. Tanya Werner is the forensic pathologist. Deputy Lisa M. DeLeon, law enforcement. Deputy John A. Martinez, law enforcement. Of course, we have Miss Deputy Kayla Rodriguez, law enforcement. Deputy Nathaniel A. Taylor, law enforcement. Detective Scott A. Lowen. Oh, it's going to be fun hearing from him. And Dr. Sarah H. Zydwick, Zydowicz, medical examiner. Vincent Batagola is a neighbor. Brandon Moats is a neighbor. Abraham Moreno is a neighbor and friend. Joseph O'Neill is an Orange County Sheriff officer. Melissa Sexton, a property manager. She was an interesting character. Mm-hmm. Yeah, ADH Jellybean, ex-husband on prosecution side. Now they may have subpoenaed him first. Doesn't mean he won't. He will be helping her. Abraham, Joseph O'Neill, Melissa Saxon. Oh, Juan Torres is a victim's brother. Moses Torres is the victim's brother. George Torres, which is the victim's senior, the father. All of them are testifying. The mother, Blanca Torres, the victim's mother. Devin Romero, the victim doesn't say. And Shandis L. Robinson. So they have the family of the victim testifying. Oh my gosh, y'all. That is insane. OMG, y'all. That's insane. Okay. So we have the defense's experts that are appointed. Let me see. And they are Dr. Charles Heller, DV, domestic violence psychologist, Dr. Edward Wiley, forensic pathologist, Dr. Michael Birkland, cream cream with my coffee? Sure. Crime scene reconstructionist. How do you need a reconstructionist of a crime scene? Oh, do you mean we get an exhibit? Do you mean that somebody is going to put themselves in a suitcase in the middle of court? Oh, y'all, this ought to be fun. I want to see a reconstruction of a person in a suitcase. Really? Michael, Dr. Brannon, clinical psychologist, expert J.D. Thomas, forensic consulting services, crime scene and forensics. John Shawalski, electronical expert. Julie Harper, forensic psychologist expert. You have multiple forensic psychologists and a pathologist. And then you have Princeton Brick Investigations, private investigator. Oh, Lord have mercy. That ought to be interesting, y'all. That ought to be real interesting. What is the delay? Does anybody know? I'm trying to find out why the delay. Oh, Squeegee of Justice is already saying, I have stories. Oh, so he'll update us with Jules. Okay, Jules is in the courtroom with Mert. Yay. Oh, Squeegee says, I'm outside, not in like we thought. No tent. It's real crazy. A lot of people are out there with him. Local Fox is here and other local stations. So he couldn't get in. Squeegee's having to stay outside unless they have a person of the same height and weight and build, the same size, and figure they can do. Oh, Haley Mouse. Yes, Squeegee, go live. Okay, let me go find Squeegee. And we'll go live with them while we're waiting for Boone. Where is your live, love? Okay. Oh, sorry.
The car. Let me get out and show y'all. All right, so this is where the magic happens. So I'm connected to this box.
Oh my gosh, they have a box out there.
And then here are the people. So this is the plaza.
Oh my
Here's the
gosh, he's
courthouse.
having to do this out of his car, y'all.
Sarah is up there. She's up there with Jules and Mert. And then, so here's that box that you connect, and then you can stream live. But then here's just some people. It is nice, actually. It's really windy, like really windy. I think a front came through because yesterday it was like 91, and today it's like 75. So yeah, it definitely is very breezy right now. But nice courthouse. Yeah, it is. It really is nice. Yeah, it's huge. I think it's, I don't know, 20 stories or something. So yeah, so here's the media, if you will. So these guys are channel 2 right there. The guy right in the white SUV there is from Fox, local Fox. I don't know who these other people are from. They didn't give a reason. This is just the way they set it up. I think they were saying since Casey Anthony, because lines apparently were all the way down here. But then it's weird because Jules said that it was in Pinellas County, which is Tampa. But Mert says it was here, so I'm not sure. We got to talk to him about that. But yeah, so I think since Casey Anthony, have you seen any attorneys? No, because I haven't been inside. Well, I was inside just to get my press pass, which I have. I got my credentials here. Doink. Let me show you. Yeah. I got my credentials there. But yeah, so this is just, it's really weird. Like if it rains, I don't know what I'm going to do. I got to figure that out. Yeah, I thought there would be like a room, where I could have my laptop and I could be, I thought there'd be a room where I could have my laptop and I could be chatting with you guys, but I do have my cell phone, obviously. But I have a viewer that wants to, let's see, just kind of trying to read chats. Yeah, here's the Society, Orlando. There's a few restaurants down here. I walked down there. There's a few restaurants down there. And actually, I ate over here. There's a ramen noodle shop over here at the corner.
Wow,
back over there. There's a ramen noodle shop over there. So I ate there. But I don't know if this is considered downtown or not. I got to kind of sort that out. But because I haven't been to Orlando in a long, long time. And if I have, I've been
This is what you do, Trout TV
Disney.
Live.
I've never really been downtown.
Hey, Trout TV Live. This is what you do. If that's your black car, you get one of those pop-up. Let me mute this music. I'm sorry, I can't hear it. My bad. So get one of those little pop-up tents and put it over that box. So if it rains, the connections don't get wet. Your cable can get wet going to your car. You run it through your window. Okay, you may have a little crack. Put a towel over the window or something. But if it rains, get a tent and put over the box so it doesn't short circuit. Oh my gosh, Trial TV Live. This is freaking insane. Not that you're going to listen to my humble opinion, but I'd have a pop-up tent in the back of my trunk ready to go. And I'd pop that sucker up over that.
We're hoping that this works for the parking people. So not sure if that will work or not, but we're going to see.
And I'd run the cable through the back window.
But yeah, nice enough day.
Good morning, everyone. Thank you, Trial TV Live.
We'll check it out. I don't know if there's going to be a bunch of people here. As the trial gets going, we'll have to see. But for now,
yeah, I know a lot of courthouses
pretty quiet. Tall. Maybe next week it'll be maybe for the verdict it might pick up. We'll see. The communications director said that she is expecting it to be pretty crazy, but we were able to get in and out of security pretty quickly. So first story is, let's see. Jules was stuck in traffic. She was coming from Tampa. She was stuck in traffic for
cover that
I think
thing.
like 2 hours or something. Should have only taken about an hour and a half. She was stuck in traffic, so she finally made it to the hotel, and then we made it pretty quickly. It's only about a 10-minute drive, so we made it pretty quickly. So I am going through security, and I have a glass bottle which has water, and I also have a little glass jar that has nuts, because in case I get hungry, because I have no idea when we're going to break and all that stuff. So I couldn't bring in the jar of water. I couldn't bring in the nuts. There's something else I couldn't bring in. I'll show you. Sorry about the wind. It might be really bad for you guys. Sorry. All right, let's see. Let's see. Yeah, I wasn't allowed to bring this in. So my water, I couldn't bring that in. Oh yeah. Oh, my gimbal. Yeah, they wouldn't let me bring that in. And then I got my little jar of nuts. They wouldn't let me bring that in. So I'm in line, and again, there was like hardly anybody there.
Sorry, Trial TV Live.
Yeah.
Squeegee Justice
For y'all. All right, so
a nut.
so I'm in line, and of course they tell me I couldn't bring those in, so I had to leave, go back to the parking garage because I didn't want to throw that stuff away.
Have an inside media pool.
Then I came back in, and I got to know the guys, the security, because they're really cool, and there was like hardly anybody in line. So I hope that continues. But I asked them, they said, "Oh yeah, no, we're expecting a lot of people." So tomorrow, or whenever they start, I guess Friday and the next week, I'm expecting a lot of people, or they were at least. So had to go back to the parking lot. Had to go back in security. And again, these guys are really cool. One guy I was talking to him about the whole live view system, this whole thing. And he's like, "Oh yeah, I'm a musician." And, he's going on and on about his setup. So that was kind of fun. So then we get up to the communications room, and luckily, and thank you to RA, Top Mark Media, my badge was right on top, and she's like, "Oh, we were expecting you." So I was like, "Sweet." So that was nice. Then got my badge, had to sign paperwork, sign my life away, basically, gave my firstborn and all that good stuff. Then we tried to get into the courtroom and couldn't get in because it was locked, and it was about 8:30. Because we were hoping, because Jules knows some court TV people, so we were hoping that we could just connect to them. So, oh yeah, the communications director said that it's court TV. You got to use their feed, but you can connect to this box that I showed you earlier. So, so we have to go down to the loading dock to get the key for the box. And I have to give my driver's license. Whoever's there first gets the key. Here, I'll show you the keys. Here's the lock. So there's the lock right there. There's a lock there, and then there's a lock on the other side, right? So you have to give them your driver's license in order to get the key. So I had to give up my driver's license.
This is Squeegee.
So I was the first one, and the guy that signed in a couple days before me, he was with Fox, who I eventually met. Really nice guy. He's here. He's in the, not this one. This is WESH. He's in that truck over there. Again, techs are really cool. They're really nice guys. They're helping me as well. So I had to give up my driver's license. Of course, I get it back at the end of the day when I bring the key back. So we come down here, open it up, and this cord here, it wasn't long enough to reach the car. So this guy right in front of us, really nice guy, he gave me this extender. So yeah, basically this is this is it. This is behind the scenes, chat. This is how we bring you. I don't even know if this is working, to be quite honest. Hopefully.
Correct. Right. Okay. And so what is this table telling you right here?
This is the reported data from the entry that was available, the one that was marked in all of the graphs
I'm going to have sound from both courts going into one ear source. So Lord help me. Yeah. You may not be able to hear me sometimes, Karen, because I have another feed simultaneously running for the Melody Walker Ferris trial. I have 2 lives going on right now. So sometimes I'm going to be talking. I'm going to try and turn off my camera so you know I'm not here when I bounce, but I'm learning.
William J. for the state.
I may have 3 lives going in a minute if this doesn't get, if the Boone doesn't. Oh, look at this sheriff. He's the nice one. Oh, look how nice he is to her. Bless his heart.
I do.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please? All right, thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th, and then the defendant's amended response to same also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion objection and motion in limine to exclude decedent's medical records filed October 14th. And then the party's objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So state, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So state, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified.
Glorious Jules, notorious Jules, none can deny it. Just saying. We have an echo. Echo? Okay, hold on. I don't know why you have an echo. Do y'all have an echo? I only have one stream up.
Your Honor, for the record, I'm having Madam Clerk mark A, B, and C for identification purposes for this hearing. A is a copy of the defendant's statements that she made on body-worn camera to Deputy Sheriff Kayla Rodriguez on February 24th of 2020, as well as the interview that she provided to Detectives Copsell and Lowen on February 24th, 2020, and February 24th.
Hey guys, I only have one of every window open, so I don't know why you're getting an echo.
For
Do we
review in
still have
chambers
one?
as a courtesy before the motion to suppress
Okay.
statements, as well as what is entered into evidence.
That may have
for the
been on
motion
their
to
side,
suppress
not
the
mine.
hearing that was held. State would move A
If
for
I have to, I'll close it out and
identification
reopen
purposes,
it.
1 for the purposes of this hearing.
Responses to what was pre-marked as A. All right, what was pre-marked as states A will be received without objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper.
Now, it's going to be
That
hard for
evidence
me
is
because
stated
I
two for
have
the purposes
2
of
live
this
streams
hearing.
going off in my ear at
Any
once.
objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
Good morning, Adair.
C for identification for purposes of this hearing is the deposition of Dr. Werner.
Oh, thank you very much, Karen.
State would move that into evidence as state 3 for the purposes of this hearing.
Any objection? All right, what was pre-marked as state C will be received without.
Sorry about that. I was trying to move the. Thank you so much for the
without
captioning.
objection
I was
as
trying to
states
move it up.
2.
I don't have control over
C
that.
for identification.
You're welcome, Eddie.
For purposes of this hearing is the deposition of Dr. Werner.
For those of you who are just
State would
hopping
move
on,
that
I've
into
got
evidence
2
as
trials
state
going on at
3 For the
once.
purposes of this hearing.
So if you see me
objection?
talking and you don't hear me, it's
All
for
right,
the
what was
other trial.
pre-marked as state C will be received without objection as states 3.
Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be
Hello,
able to
Zach.
assume
I
that
got
that
2
will be
streams
testimony
going.
at trial, given
Both
that
the
her
Boone
latest
and the Ferris
version of
trial.
events was just given to our
Welcome.
experts
Thank you for
last
joining us.
week. So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire that. That was not the purpose of our motion. I don't think we mentioned voir dire. Because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues. during
Good
the
luck,
jury session.
toxic.
But what we are asking
Extra hugs.
from the court now preliminarily is,
Hey, howdy over here
if
too.
that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony was is, we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is, we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing. We're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually it comes to a point in time where they're sitting on the couch and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes as nearly entirely shut, but two fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death.
We're
It's
having
only
a
when
good
he
day.
begins to say, after
Good day.
she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time. When he starts to say, "I cannot breathe," now she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out. And she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error. But this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what you're asking for is a ruling that if, and this is a motion in limine,
oh my, it was a good
okay,
day.
this is what's proffered to the court prior
Plenty
to
of
trial. If this what comes in
alcohol
at trial,
headed my
this is the court's
way.
preliminary ruling,
Zippity
unless something changes.
zippity.
What we're asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence,
Go ahead, sir.
or battered spouse.
That
syndrome
was not
evidence.
me.
And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in. And her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
Good morning, Judge.
Morning, sir.
I'm a little confused, but I want to make sure, so probably can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say
One of
there should
Boone's
be
new
no
attorneys.
mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
Oh, this is getting good, and we haven't even started yet. Yes, that's one of her attorneys. I think she has 4, if not 5, on her team. Go figure.
Judge, if I could have you repeat that question.
Sure. So my understanding, well, let me ask, I'll have a more of an open-ended question. What is the basis factually of Dr. Harper's opinion? So if we were at trial right now for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step 1 under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told in outside sources too. They are able to make a determination based on their training and experience. So,
But based on the Akendo case, which is cited by the state as to what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but
What
that
is it?
has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct
Like
that
the
would
word
be
linchpin.
permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
If you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone, or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct. Parties are allowed to get motions. in
This is a
limine based
very,
on the
very
proffers of
huge
evidence
decision.
that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days
He
earlier.
went there.
Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out,
He's equating him to
drinking
a
some
dog.
Woodbridge Chardonnay.
Oh,
And you put the
Jesus.
dog in the suitcase, and then
you
the
kidding
dog
me?
barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up.
Oh my
That
gosh, are you going
triggers
there?
you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking,
Yeah.
unless they are saying that
Are we?
testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing, and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Judge, can I respond?
Briefly.
He's like, I'm not going to do this all day. Get it done.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is in the state's argument, in the case law, which the case law has been presented by the defense in your filings are not germane
Yep.
to the issue. We're not
Boone?
addressing jury selection and the standard of proof and the burden
Does
with
Boone
regard
need-
to
does
self-defense,
Boone need
you
a Boone?
establishing a prima facie case. and
Does
then
Boone need a bone?
the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Miss Boone, that element seemingly is lacking. We all know what elements are, right? It's a negligence case, it's duty breach causation. In this case, it's
Y'all
the
are
elements
bad.
based
I
on the
love
jury
it.
instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
Yes.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Okay.
That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence because there's a
But
picture
she could
provided
have left.
of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't.
But
and it's based
he's
on
upside
all the
down in a
evidence the case,
suitcase. He
just
ain't
not
getting out.
testimony, but also physical evidence that might support the testimony.
Thank you, sir.
But
All right,
she
the court has
could
had the
have
opportunity
left.
to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N,
Yeah,
v. State,
Haley.
182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th ECA in May of 2023 WL 3262633 at Pinpoint Site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony.
So she's going to be
provided
forced to
for the expert to
testify.
testify to the battered spouse
Exactly.
syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in LAD 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning,
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under LAD needs to be established before any expert opines to battered spouse.
my concern is open. Can it be
So that means
Yes.
she's going to have to
That's your
testify
decision.
herself.
That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter?
That was a smackdown. That's going to hurt.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you.
They're not
Moving now
happy.
to the defendant's motion in limine filed October 6th and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
Snap, that really hurt them.
Okay.
It really, really did.
The rule of sequestration applies.
And they
to
know it.
testimony of other witnesses, not to anything else.
Response?
Not from the state. I said there's no state witnesses.
So that's a no.
Ooh.
May proceed with any argument, Mr. Owens. Yes, sir.
It's getting tissy. Ronnie, how long was this break over here for the Melody Walker Ferris trial? I couldn't
I
hear
have
it over
reviewed
the
2.8
speaking in this
instruction prior
case.
today. Thank you, Counselor.
Judge, the problem is the state's attorney, when they filed the response, they didn't include the highlighted portion that's
Let's spell the
italicized at
4 or
beginning.
5 letter words
Police
differently so I don't get in
opinions and
trouble.
statements
Thank you.
regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the
It's okay, I
following
just
limiting
don't wanna get in
instruction
trouble.
immediately before the recorded interview is played for the jury. That section,
You're good, Toxic.
which is comments directed to the court, was not placed, to my understanding, in
But
their response.
you're correct.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes. the
They're
2-minute
coming back in the
video
Melody Walker Ferris
Sarah
trial.
had recorded
They'll be
and
back
then
in a
followed
minute.
up 11
They
minutes
just had a
later with
camera view change. So if y'all
22-second
want to
video that she
go back over
recorded
there
that they
and
found
back
on
and
the
forth,
phone,
just let
which
you know.
I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that any which way they possibly could. And the law says that they're allowed to use, and I cited several cases, cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases, the
I didn't
court-
see a citation to Eugene. I mean, Eugene's included in ODA, but I don't,
Eugene is found, do you need the site?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when
Only
detectives
a
made
2
some
hour.
statements
People are there sometimes
that
for
are
12.
highly
Please.
prejudicial
When?
to the defendant
2 hours
and
is
tend to
nothing.
be opinion and tend to invade the province of the jury.
Well,
And that's
I
why
do.
this special jury instruction
Y'all are
2.8,
bad.
recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
I think she stole her. Remember how she was getting a 5-finger discount from the
That would be read.
officer's
I didn't
desk and
feel it
stealing things?
necessary to include
She stole pencils and
italicized
paper. She's
portions
good.
of comments to the court because this is what we get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this
I
question
can lie.
first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about.
No, the words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when she says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
I hope he does
State
not take
attorney
it
might
out.
Put that in there, the italicized portion, where Supreme Court is giving instructions to the court with those comments. For them not to put that in there, I disagree.
Okay, well, the Jackson case speaks for itself, and the court has reviewed it.
Thank you.
All right, thank you both for your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response, that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death.
They won
So the
that
court is
battle.
going to grant the state's motion, as under the Bush case cited by the state, law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from. I apologize.
won.
Thank you. The defense's
Defense
motion is
won.
granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regards to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me.
I do not have
That
sound
takes
on the
us
other
now
court.
to the
They haven't got it.
state's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
Did you notice her little hand pull back when the attorney went to take a piece of paper and she goes,
Received 550 pages
like,
of medical
"Excuse you."
records regarding the treatment of Mr. Torres from two incidents, one in 2017 and one in 2018. The third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I've not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to
Good
weigh
point.
and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment. That narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I mean, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the
I
court right
understand
now.
that. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, Jorge Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up.
Thank you, Toxic.
But yes, I
The
agree
Melody
there's gonna be a
Walker Ferris
narrowing down,
trial
but
is back in
it's kind of
session.
premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have Jorge Torres' medical records prior to me sending them to you? All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on Jorge Torres' medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that, but they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be.
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony.
You are the proponent of the evidence. So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down since
Well,
we have some level of common ground here?
My case is not going to be presented, I would assume, until next week. So I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow
really?
it down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not
Hello, guys. We have lost our power. I'm in the process of right now of trying to get this back on. Ronnie, can you get a hold of Miss Kevin and see if she can host the live for me while I try to do the same? I am so sorry, guys. I can't share screen. I'm trying to get a hold of someone to host it. Just hold on, guys. Okay, guys, I'm sorry. We are down for power. I don't know what's happened. Yep. My apologies. I don't know what to do at this point. There has been some construction outside, so yeah, I'm a little bit perplexed. Hey, welcome to the studio. You get to see the whole backdrop and everything. Yeah, I just talked to her. Ronnie, can you reach out to Sneaky? I think they're the only two who can help me in this situation right now. I can't, I need to get something. Yeah, I can't do that. I have no means to do anything right now other than what I'm doing. So I apologize, guys. There's nothing. I'm out of luck. No power. So as of right now, the prosecution has won the partial win for the motion on whether or not they can bring up the battered spouse. They did not win keeping it out fully, but what they did win was to have to be able to it has to be brought up in testimony by Miss Wonderful Sarah Boone. So yay for her. I mean, they won that. Oh, I'm so sorry. Is it that cold up there? Sneaky, we need you. Sneaky may not even be home. Yes, the bill was paid. Yeah, so they're not going to be able to bring up the battered wife syndrome or spouse syndrome unless, literally unless she gets on the stand. So they're going to have to put her on the stand pretty quick. Sorry about that. They did get the defense got a big win with keeping out that information. This is not a good angle. I don't look like this normally. Normally I'm more like this. Okay, so I'm not this wide at the bottom. Can I turn this vertical this way? Nope, I cannot. So they got a huge win on the defense when it came to the wording. When in the interrogation room, they had said, well, basically, he would not have been alive if it wasn't for her. So that's a good thing. They did get those removed because the judge felt it was inappropriate. So that was a huge win for her. I think Sarah wants to testify. However, I think that the prosecution made a very good point, and that is if she should change any part of her story, which she can do, she's going to have to do it under a narrative versus a questioning testimony, which will be to her detriment. If she goes narrative, she will royally be in trouble. Because if the lawyers know that she's going to lie or tell falseness on the witness stand, they cannot go up and question her, like in the Robert Tellis trial. And by the way, he's being sentenced today. I'm so sorry, Toxic. Oh my gosh, I am so sorry, babe. Are you kidding me? Oh, Mija, I'm so sorry. Oh man, that sucks. Especially with the baby. We are in my son who's owns the business that I'm using his space in is trying to figure out how to get the electricity back on and how long we're going to be out. Hold on a minute. Okay, cortisone break for 15 minutes. Does anybody someone want to hop in and kind of fill us in on what's happening? Are you sure you're not in the UK? Toxic orchid getting cold, waiting for buses is kind of our thing. Yeah, I don't do well in that. Y'all get to see my beautiful storm pictures. Yeah, this is fun. So hopefully we'll have our power back on by then. They're working on it. They are working on it. I'm sorry that I don't have a backup. I'm gonna go ahead and yay, we have power. Hallelujah. Okay. All right, guys, let me get it going. Let me get this back on. Why isn't the computer coming on? There it goes. Okay, yay! There must have been some kind of, we get accidents and power outages on a semi-regular basis around here. For some reason, we do have a lot of new construction and stuff going on, so there's a chance that one of the little cables got hit. But we'll be back on by break. Yay! Y'all. Wow. Okay, come on. I'll be right back. Okay, the power was on. It's going to take a minute for the internet to click in. But we are getting back up and going. Lord willing, we'll have everything back up and running. Refresh. Oh, YouTube. Come on. I'm working on it, guys. I am. I'm so sorry. In the meantime, you get to see my dirty office. Yay, internet is up and running. Okay, that's going to pause there. Let's get this. We're booting. We're getting there. I got about 5 windows to get up. But thank you guys for sticking with me. I am so sorry. I'm just going to close all of the windows out and start it again and see if that's up. Okay, great. So new tab. StreamYard. Okay, we're getting it back. We're getting everything back. Woohoo! StreamYard, put that over there. We're going to open up another StreamYard. Get that one open here. Oh, Boone Enter Studio. Gotta get camera up and running. Camera's up and running. Okay, I am removing this one, getting me back on screen. I'm exiting out this one. I'll be right back, y'all. Y'all have. I'm not offline, dude. I'm online. There we go. Let's see if we can get Boone back. All right, we got Boone back up. I know I got to get sound. Wait a minute. Why am I not able to change my layout? There we go. Okay, testing. Can y'all hear me? Please, someone let me know that y'all can hear me. Not that I have a beautiful deep voice, but you know what I mean. Oh, I'm so sorry about the baby. What the heck is going on? What the heck? What? We're reloading this. This shouldn't look like this. I'm working on it. Poor baby, toxic. Is that going to be a surgery? I don't know why everything's running slow. There we go. We want the trial. There we go. Something just beeped. I have no idea. Yay. Hallelujah. We got that one up. Okay. Are y'all able to hear me at all? I'm not hearing me. I got to reconnect my hearing aids. That's what I need to do. There we go. Reconnecting here. Hey, I can hear me. Okay. Can y'all hear me? Someone needs to say yes or no. Otherwise, I want to keep saying, can you hear me? Can you hear me now? Can you hear me? Oh, Ronnie, are you hearing me? Okay, good. Thank you. I'm going to have to recreate the other live. I lost it. Dag nabbit. I'm so sorry. Thank you, Sonia, for joining. Everybody who stayed with me, thank you so much. It's going to be a little iffy. Everything went down, the internet, everything, and I'm working on it. I may have to go reboot. God, I hope not. So let's just give it a minute to catch up. I may forego the hearing for now and do it. We're going to halt right now on the, I'm going to wait on the burn pile murder, Melody Ferris, until everything calms down. I'm sorry. Well, from Spain. Well, welcome. I could put a new notch on my map. I think you're the first person from Spain. Thank you so much for joining. I apologize for any inconvenience. We had our power and everything go down. But that said, we got it back. I hate to say this, I may have to come back in. Patience, I'm going to go reboot our internet. I will lose you. Stay here. I'll pop back on. I'm sorry, but I think that's the best thing. Okay, I'm back. Oh, let's see if that fixed everything. Sometimes when you have everything gets cut immediately, it kind of jacks with the system. So I believe we're up and running now, I hope. I'm going to get this up and running. Why don't we enjoy the other stream that we were watching before this ended? This is Squeegee, Justice
He's in that
with
truck over there.
Trial TV Live.
Again, techs
and
are really
he's
cool. They're really nice
giving us
guys.
a
They're
behind the
helping me
scenes
as well.
tour. Let's watch
so I had
that
to
for
give
a
up my
moment.
driver's license. Of course, I get it back at the end of the day when I bring the key back. So we come down here, open it up, and this cord here, it wasn't long enough to reach the car. So this guy right in front of us, really nice guy, he gave me this extender. So yeah, basically this is this is it. This is behind the scenes, chat. This is how we bring you. I don't even know if this is working, to be quite honest. Hopefully it is, but this is a test run, and if this works, great. We will be streaming. Again, thank you to Top Mark Media and RA and Recovery Addict. Big shout out to you. We're going to see if this works. But now that I've gone through this process, now I know. Oh, and then the final thing is the whole press pass thing. And I was talking because the parking little parking guy comes by and he's like, "Do you have credentials?" And I showed him my credentials, and he's like, "No, you need a placard, to put on the front here, on the dashboard." So I'm like, "Well, I have something, but it's upstairs, or I have to." So he was explaining it. He's like, "I could just give you a citation right now, or you can move." I'm like, all right. Let me just give me 2 seconds. So he took off, and I had Mert go upstairs and bring down my badge here. But then he also brought this badge here, the press, this press thing here. So this is Mert's press thing. So hopefully this will work. If it doesn't, then I'm going to have to move the car and get some kind of official press credentials. So anyway, it's been a day. It's been a day, and the hotel I'm staying at. Oh my God, this hotel is interesting. I'm not even going to get into it because it's lack of toilet paper, cockroaches as soon as you walk in. It's
Ew! Poor baby.
It's been a night and a day, but I was able to get some sleep last night, and going back tonight. Let's see, today's Wednesday, Thursday. Not sure if I'm going to stay there next week. We'll have to see. But yeah, man. So that's it. That's it, chat. That's what we got. Let me see. You guys got any questions? Throw some questions in the chat. I'll try and answer.
Wow.
Jules really is the one. She's in the courthouse right now in Mert. I'm outside staying out of the wind. You can see how windy it is. I mean, again, it is really windy. Yeah, it's really windy. Oh, thank you, Joni. I love you guys too.
We really do appreciate them.
Just standard traffic.
Fabulous.
Standard downtown traffic. Yeah, I do not miss big cities at all. I was in New York City for like 15 years, and then Fort Lauderdale, and West Palm, and do not miss big cities at all. This I do not miss. Because you're streaming the feed, you have to go outside. Yes, therapist, this box right here that I showed you earlier, that's where this feed is coming in. And then I'm streaming it out to you guys. And I'm hoping that Scott, because he's got it under remote control, I'm hoping that he is streaming that right now. But Court TV, the court gives one platform, and Court TV is the one they gave it to, of course. So they are the ones that have the camera, the pool camera, or the camera pool. I guess it's the pool camera. So they are actually in the courtroom with the camera and an operator, and they are streaming it. Then they stream it out to this box here, and then we stream it. We plug in, right? So we all plug in, and then we connect to our little live views. Y'all should really tell the other stream that is live that y'all have moved to this stream. Yeah, I'm not sure, Dizzy. I'm not controlling that. That's up to Aaron and other people. There's about 30 people in there asking for an update. I'm not in the courthouse or courtroom, so I don't know.
Thank you, everybody, for sticking with me. Oh my gosh, things happen when you go live. Can't help it, but I'm back up and running. Thank you, Jesus. In the meantime, we are going to take a little. That was intense. That was intense. So I, again, apologize. There were so many of y'all watching, and I hope y'all hop back in. But unfortunately, things happen, and everything went down. So can't control what goes on in the outside environment that may affect our power and internet, but we're back up and running, and thank you. I did have to restart this live. So if you're watching me on the Melody Walker Ferris trial, please say hello. Ronnie, if you want to hop on over there and just to get it going, that would be great. If not, you can stay here. So in Spain, that would be 5:43 in the afternoon, our time. Sonia, I have 2 lives going at one time, and you may see me talking with no sound just because I'm commenting on the other live. I'm doing a dual live, and we're going to see how this goes. It was going good until the power went off. But anyway, thank y'all so much for joining. Can somebody catch me up on what happened with the Boone, or should we back up? Do y'all want to back up?
It will
We
be
can because
relevant
they're behind.
after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down? Since
Well,
we have some level of common ground here.
My case
Okay,
is
so
not gonna be
we've saw that
But they were
part.
sitting in Miss Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case, or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both, and the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day. And that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling? Defense. All right. Thank you. That now takes us to the objections to the evidence. Give me a moment. We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's fifth amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item tracking their fifth amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's third amended exhibit list. When was the fifth amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left. So I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a one-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay. All right. I need clarification, Mr. Owens, as to when the fifth amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that. When it was
Knocking them underneath furniture,
All I have is a notice.
on refrigerators,
So
washer,
on September
dryers.
27th, there was a
shelving
notice of
units.
provision of defendant's
They'll be under
third
their
amended exhibit
couches,
list.
chairs.
And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else and let you
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second. Okay. All right. I got an email this morning from Juror Services.
Interesting day.
Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3. That would have been yesterday morning, seat 48.
She stood up for the judge.
Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around. The other juror 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when two of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor? Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in like sardines?
Good observation
Response.
and point.
Can you all approach this for a second?
We just got a crazy phone call. They my son has a business and it has nothing to do with CBD, THC, or anything like that. And someone has called twice today. One wanted to know if we had THC vapes. Oh, I muted both. I'm sorry. My son has a business and has nothing to do with THC or CBD or any of that. And we've had 2 calls today. People, excuse me, do y'all carry synthetic urine? I'm like, ew, no. Paula, that's a good observation, possibly. I'm so sorry, toxic beloved. I know that is so miserable.
All right, court's going to take a 15-minute recess to address jury selection location this afternoon, and to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the, well.
I'll explain in a minute, Haley.
Then I don't have a motion for cause.
Okay. Any response from the defense? Correct. That is correct.
So the Sarah Boone is going to take a 15-minute
I read
break.
you what was provided to me. Okay. Court's going to be in a 15-minute recess. Thank
Wrong
you.
one. My bad. Let me get the right one going. I apologize. This is the one we need now. My bad. My apologies. I'm going to back it up to here for this woman's testimony that we missed. Let me hit play. Get biggin. So I think, okay, so they're on a long break. Okay. So those of you who want to know, I have two logos in front of me. One says the Great Seal of Florida, In God We Trust. The other is the State Seal of Georgia, Wisdom, Justice, and Moderation, the Constitution. Interesting. Okay, why were they? Okay, they're not taking synthetic urine. They use the synthetic urine as a means to try and pass a urine test illegally.
We're back on
No,
the
we
record,
don't tell
2020
that.
CF 2603, State of Florida versus Sarah Boone. State.
Toxic.
Defense.
Get warm. Get under a binky.
Ms. Boone is still seated at council's table wearing the same gray suit and white blouse from this morning. Can y'all approach?
Why do we need to know that? Some of y'all have asked, this is the Emily D. Baker special lip gloss that she partnered with somebody, and this is objection. I bought it to support her. Well, we're talking about the Melody Walker Fair's case. The defendant Melody has not been standing for the judge at all, or the jury. And that, my dear folks, is horrible, disrespectful, rude, and obnoxious. And I don't like it. But the judge has not enforced it. What can you do? Oh my gosh, that looks heavenly. Oh, did I just see my next dinner? Cornbread in a waffle iron with beans and cheese. Oh my gosh, y'all. Look at that. Cornbread, chili, cheese, cornbread, waffle. That looks heavenly. No, I don't think she has a medical exemption. She's walking and standing fine. I've just noticed she's not been doing that. Don't know. Oh, come on. Don't start this.
That's the context of.
Let's zoom.
We're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Kester on behalf of the state. William J. for the state.
Defense.
Thank you,
Ms.
Ronnie.
Boone is still seated at council's table wearing the same gray suit and white blouse from this morning. Can y'all approach?
So they approached and then they came back.
Digital
There we go.
exhibits. I'll turn it over to you, Mr. Owens.
Judge, and I did want to say that the notice of provision provision of the defendant's fifth amended exhibit list was e-filed on October 3rd.
I know, right? Indian tacos. I've got to learn how to make me some fry bread.
Correct. But the same problem I have is it's just the notice of provision. I don't know what any of the substance was. All right, you may proceed, sir. Okay, go ahead.
And Judge, this was a little bit of a new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence. The state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that time. Something might make something relevant at a certain time, or it might not make it relevant. So there. And also as to just the foundational stuff, because the images, as I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd, 2020 date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is laid, that's my problem with these photograph exhibits, is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay.
Response?
Is this going to be considered a separate hearing for the record? So should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing. So I believe it should be pre-marked as D.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction
I
carve
have an
out.
electric heated pad on my bed
What it has
and an
is
electric
what,
blanket.
and we were
I get you.
even so specific that we labeled one part of the PDF case in chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case in chief timeline. Count up as 80 photographs and videos. Attachments and rebuttal. Count up as 147 photographs and videos. There is metadata that comes with all those files. So there is a date stamp and time stamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one.
Thank you, Ronnie.
10/26/2019, 6:06 p.m.
We also
all
have
have
the
file
TELUS sentencing
providing
at 12.
context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this as states 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? All right, that will received without objection as states 4.
So just to give the court an example. On page 49 of 59 of the PDF labeled Case in Chief, entry 31107 in this PDF from the phone extraction is labeled videos, 2/23/2020, 11:12 p.m. 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is the case in chief timeline has a conversation that begins
Can you find where it's going
on
to be
Christmas
streamed,
of
and I'll try and see
2019.
if I can do a fourth live.
And it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boone, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th. Then it goes down to conversation that's going on January 12th into the 13th of January of 2020, culminates in a text from the owner of the phone saying, "And bless you and all of you too, I'll get capitals rid of him." So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages. It starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there was problems with all the time. It's going to give some context to those things.
Thank you.
Mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these time frames. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child, any of that child's friends. There was no need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these timeframes. We did our best to narrow it down to what timeframes we believe will give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason. We believe that everything.
We will watch the Richard tell us later. It's already happened. I apologize with everything that was going on. It's 11 o'clock my time. So we will try and get the Menendez brothers up and geared, ready to go. We'll watch it during break. We'll watch it. Oh, sorry.
Is
There we go.
relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was relevancy, foundation, unknown origin date, hearsay, and Crawford issues. I'm submitting for the court, if I can approach the court. Gilbert versus State, 324 Southern 3rd, 598 from the Second District Court of Appeals decided in 2021. Lamb versus State, 246 Southern 3rd, 400 from the 4th District Court of Appeals decided in 2018. Gale, Gayle versus State, 216 Southern 3rd, 656, 4th District Court of Appeal case as well in 2017. The basics of these three cases are just the very low bar for authenticity. As Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction. So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Miss Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women. But I believe the context of those conversations makes it clear who is using the phone and who is not using the phone. So we believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and
I'm
getting
going there
rid
now, Toxic.
of
Thank
him,
you.
plus the timeline of the date of the offense. Then the rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone can be inferred from texts, and how the relationship was with the family and who may or may not have been the psychological aggressor. As far as hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the cases I gave to you makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the confrontation clause that he outlined in Crawford versus Washington in 2004. What he also talked about, though, and what has had some discussion since the Crawford decision was what's hearsay versus testimonial hearsay. Obviously, there's no testimonial hearsay in these phone extractions. There's no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay and it's not testimonial hearsay, much less. And the conversations that are going on with the other people, the statements that other people are making back.
Sorry, real quick, I need to let everybody know, Toxic Orchid and Ronnie, it says that their live stream will start at 3 p.m. I guess that's Eastern time. That would be 2 p.m. my time, Central, correct?
Back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted. There is no hearsay issue. It is to provide the context of things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of, or screaming at his family, so on and so forth, demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you, I'm working. So those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that there is a date and timestamp to every single entry from this phone extraction, and that corroborates with the images, most of the images, some were from unallocated
Yes, I did
space,
get it, Toxic. Thank you.
but it corroborates the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, but now the court has a copy, and hopefully we can get advice from the court if the court is believing that there are sustainable objections before we swear in the jury, so that the state can pull any photographs or videos, or we can have at least a discussion about those specifics. And then after discussing those specifics, the state can pull those out before burning a DVD to provide the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but so that we're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you. Response.
Judge, I think this procedure calls for a lot of speculation as to the defense part, as to what these photos, examples. Yes, Your Honor.
State. Response. Benny.
So what are we waiting for them? Yeah, I know, right?
I don't believe so in either of the
Could have been premeditated.
folders. I don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any.
Yeah, toxic. This is new information that we've not heard before. Could have been. And you're right. Wow, y'all. Y'all. Let me hop on this stream. Okay, guys, on the Melody Walker Ferris trial, we are still in break, but as soon as they come back in trial, we'll be up and going again. Let me get some music going. I'll be right back, y'all. Ronnie, we'll keep an eye out for it. So, Ronnie, it may be 3 p.m. our time. We'll just keep an eye on it.
Okay, I see two images. I couldn't recognize it as reflection of children in a, I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection to removing those two. I just didn't recognize it as children. I recognize it as a crab.
I haven't seen the picture, so I'm at a loss.
Well, sorry,
Really?
the extraordinary file name, but
Oh.
I'm going to remove those two exhibits at their
Can I take care of that issue for you, sir?
That takes care of that issue, Judge.
Okay.
But the point that I'm trying to make with that and why I raised it is that there are going to be certain things that I'm not going to know into what is the purpose of it as far as how is it relevant now. They can make a proffer. I understand they can make a proffer, but their proffer isn't evidence. Once it goes up, the witness is in all, and the court has told me that I don't waive my objection, so I understand the court's ruling.
All right, thank you very much.
Yes.
Anything else with regard to the defendant's objections to state's digital exhibits, Mr. Henderson?
No, Your Honor.
Okay. Moving now to the defendant's fifth amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed. It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. Mike, My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I just want a ruling before we swear in the petite panel.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday and turning it over to you without having a ruling on these? And we could address these objections tomorrow morning before we bring in the balance of our panel? All right, is that acceptable to the defense? Okay, all right, so then here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return, and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you.
Okay, that be done, y'all. Okay. Whew. Yeah, this is going to be hard. He is. I really like him. Let's kind of keep an eye on her. So she's going to wear the same suit every day? I mean, I like that blouse a whole lot better than that sea green she had with it yesterday. Did you see that look? Oh, let's go back and look at that look again. Watch. She sees the sheriff deputies coming. Did you see that look? Great. I got to get chained up again. She's so not likable. What is this with her hand? She does this a lot. It's like prissy. I love watching. Woman, you should know how this is done by now. Yeah, she's at least a size 8'10", at least. Boy, she's got that routine down. Yep, she sure does. And look how they're holding on to her. I've never seen them that controlled of an inmate before. I do like the suit. Maybe not the color, but I do like the suit. So we be done with Miss Sarah Boone. Okay, guys. No more to see here. We're done with Miss Boone. That's one live down. I've got 2 more to be going. So I will be live on the other channel if y'all want to come join us. We are in recess for lunch, but they should be starting shortly for the Melody Walker Affairs trial. And then we're going to, right now, we're going to go, while we're over on that page, we're going to go watch the telesentencing. Okay? So I'm going to start that in a minute. Thank you so much for joining me. I appreciate your patience today. Y'all been fabulous. Y'all have an amazing, amazing day. And I can't wait to see y'all tomorrow, hopefully with opening statements. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.